restricted to the nexus test wherein the court may only determine if there is a rational nexus with the object sought to be achieved. That is, to determine the relationship of the means to end. Any other test, including the proportionality test, would impinge on the freedom of the executive and the legislature in enacting and implementing economic policy measures. Going any further would also dilute the well-established and oft-repeated universal position of law that courts should not engage in so-and-so solicitation in promotion of economic measures. Now turning over to page 17, para 3.3. The submission that the objective stated in the impugned notification dated so-and-so are false and illusory objective is a submission calling for examination of the merits of a policy decision. Equally, the test of proportionality is also a test to be applied to the merits of the decision. Submitted that having regard to the scope of the jurisdiction in Article 32, read with Article 13 of the Constitution, where Article 13.2 says if a law is repugnant to the extent of violating fundamental rights, to that extent repugnancy it is void. That will be the criteria which courts will apply under Article 32. Now, read with Article 13, the merits of the legality of a decision, particularly in policy matters, will not be scrutinized. It is wrong to suggest that the three factors, namely terror financing, black money, and fake currency, remain as challenges to the sovereignty of the nation and its economy should not be addressed at all. It's equally wrong to suggest that because of the very nature of the challenges, chasing them will all be a formidable task and therefore illusory. It is submitted that no state action can be subjected to scrutiny on such propositions. Equally, except on state action being repugnant to fundamental rights, this Honourable Court will not convert itself into the third chamber of Parliament and declare on the political expediency or otherwise of a given measure. The suggestion that courts can scrutinize if false and illusory objects are being pursued is not the legal test which can be applied on any norms or standards, and asking the court to do so will require the court to enter into an area not constitutionally ordained. Executive policies and legislation alike are given effect by the respective branches of government with certain objectives and goals in mind after consideration and deliberation. This may not preclude the possibility that the said objectives or goals may not always be achieved to their fullest extent, or there may be something left to be desired in the manner of their implementation. This does not, however, mean that the policy or legislation in question is per se bad or that it deserves to be struck down or rolled back altogether. Well settled that a mere potential for misuse of law or a particular provision of law does not invalidate the law itself. Even a particular law may lend itself to an implementation which is improper, unreasonable, or create discrimination. That alone will not be sufficient to hold the law as invalid on the touchstone of Article 14. In such a case, it is the action under the law rather than the law itself which will be held to be invalid, and there will be no occasion for the court to canalize the manner of exercise, lay down guidelines for implementation thereof. On the contrary, there is presumption that until proven otherwise, the administration of the law is being done in a fair, equitable manner. Particularly in the context of economic decisions, the Honourable Court in Arun Kumar Agarwal has held. Matters relating to economic issues have always been an element of trial and error. So long as the trial and error is bona fide and with best intention, and such decisions cannot be questioned as arbitrary, capricious, or illegal. This court in state of MP was so-and-so, referring to Frankfurter. We must not forget that in complex economic matters, every decision is necessarily empiric, and it is based on experimentation or what we call a trial and error method, and therefore its validity cannot be tested on any rigid a priori consideration or on a question of aptly any straight jacket. In Metropolis Theatre, I read out that portion today morning. Then paragraph 4, I only
Please proceed.
Paragraph, then the next page. So the heading talks about economic legislation not permissible. I only read paragraphs 4.3 and 4.4.
Yes.
The court cannot be called upon to render decisions on the question between inaction or perfection in the sphere of economic policy and legislation. The court shall not render decisions or declarations into moot or academic question, particularly no tangible relief with reference to alleged procedural unreasonableness can be meaningfully granted. Now, one small correction I would like to make in the written note. I think you logically turn to that page 10. There is a small correction I would like to make. Para 2.4.11. There's a small mistake which has occurred here. In that paragraph about a word more than once in a section, in the fourth line, the first any, but the second use of the word, I think it should read as the word any may be singular or otherwise.
May
be singular or otherwise.
Otherwise it's supposed
that also because we are discussing in the morning.
No,
It can't.
cut and paste, something has come wrongly here.
If the government takes a policy decision to wipe off the entire currency.
Correct. It can be singular, it can be plural, it can be anything.
So we hope that such a situation may never arise. But then ready.
I have done with this note. May just
very comprehensive note, Mr. Attorney.
I'm extremely glad.
All right.
And
Well researched.
obliged. I wanted to just bring to your Lordship's notice on the excessive delegation. Had handed over a note. Therefore, please hand, please. Okay. In the first judgment, which goes back to the year 1944, the third paragraph. As we have said, the Constitution has never been regarded as denying to the Congress the necessary resources of flexibility and practicality to perform its function. And irrelevant, the Congress might itself have prescribed the maximum price or have provided a more rigid standard by which they have to be fixed. For example, that all prices should be frozen at the levels of obtaining during a certain period, a certain date. Congress is not confined to the method of executing its policy, which involves the least possible delegation of discretion to administrative officers. Then the next judgment, the first paragraph, Section 232B of the Trade Expansion Act of 1962, amended by so-and-so, provides that if the Secretary of the Treasury finds that an article is being imported into the United States in such quantities or under such circumstances as to threaten or impair the national security, the President is authorized to take such action and for such time as he deems necessary to adjust the imports of the article and the derivatives so that the imports of the article will not threaten to impair the national security. President Nixon's 1973 program apparently did not fully fulfill the objectives to which it was directed. Accordingly, the Secretary of the Treasury, acting pursuant to so-and-so, initiated an investigation to determine the effects on the national security of imports of petroleum and petroleum products. When the Secretary of the Treasury, Simon to Assistant Secretary, directs the Secretary, if it is appropriate to do so, hold public hearings, otherwise aforesaid interested parties an opportunity to present information and advise as part of such an investigation. And it goes on, the next paragraph. The Secretary submitted a report on the investigation to the President, intimating that the measure then in force under 223B had indeed not solved the problems with the director. Secretary indicated the United States dependence on foreign oil had continued to increase since 1966, and that foreign sources currently account for well over a third of domestic consumption. Secretary concluded crude oil, principal crude oil, derivatives, so on, etc., and related products derived from natural gas and coal are being imported to the United States in such quantities as to threaten to impair the national security, and the foregoing products are being imported to the United States in circumstances as threaten the national so and so. Then next para 5.555, the President agreed with the findings of the Secretary's investigation, concluded the necessary and consistent national security further discourage importation to the United States of petroleum products, and related products. Presidential proclamation invoking 232B issued a proclamation 75 with effective immediately raised the so-called first-tier license fees that imposed in 1973 to the maximum levels previously scheduled to be reached only some months later. Then one paragraph later, in Hampton, so-and-so, United States, this court upheld the constitutionality of a provision empowering the President to increase or decrease import duties in order to equalize the difference between foreign and domestic production costs for similar articles. That the court said, if Congress shall lay down by legislative act an intelligible principle, the President is directed to confirm such legislative action is not a forbidden delegation of legislative power. Then, and fulfills that establishes a clear precondition to presidential action inter alia. Finding by the Secretary of the Treasury article being imported in United States in quantities, circumstances that threaten impair national security. Moreover, the leeway that the statute gives the President in deciding what action to take in the event of preconditions are fulfilled is far from unbounded. The President can act only to the extent it is necessary to adjust the imports or so and so. And in the light of these factors, our recognition of necessity fixes a point beyond which it is unreasonable and impracticable to compel Congress to describe detailed rules. So we see no looming problem of improper delegation that should affect the reading of Section 232B. Then, let's kindly turn over to the Indian law, serial number 6, Gwalior Rayon. Delegation of lawmaking power has been said as the dynamo of modern government. Delegation by the legislature is necessary in order that the exertion of legislative power does not become a futility. Today, while theory still affirms legislative supremacy, we see power flowing back increasingly to the executive. Departure from the traditional rationalization of the status quo arouses distrust. The legislature comprises a broader cross-section of interests than any one administrative organ. It is less likely to be captured by particular interests. We must not, therefore, lightly say there can be a transfer of legislative power under the guise of delegation, which would tantamount to abdication. At the same time, we must be aware of the practical reality. Thus, Parliament cannot go into details of all legislative matters. The doctrine of abdication expresses a fundamental democratic concept. At the same time, we should not insist that lawmaking as such is the exclusive province of the legislature. The aim of the government is to gain acceptance for objectives demonstrated as desirable and to realize them as fully as possible. The making of law is only a means to achieve a purpose. It is not an end in itself. The end can be attained by the legislature making the law, but many topics, the subjects of legislation or such, they require expertise, technical knowledge, and a degree of adaptability to changing situations which Parliament might not possess. Therefore, this end is better secured by extensive delegation of legislative powers. The legislative process would frequently bog down if a legislature is required to apprise beforehand the myriad situations which it wishes a particular policy to be applied and to formulate specific rules for each situation. And that's as widely stated as necessary, if I put it like that. The presence of Entry 8 clause in many of the statutes is a pointer to the necessity of extensive delegation. The hunt by court for legislative policy or guidance in the crevices of a statute or the nook and cranny of its preamble is not an edifying spectacle. It is not clear what difference does it make in principle by saying that since the delegation is to a representative body, that will be a guarantee delegate will not exercise the power unreasonably. For if ex hypothesis, the legislature must perform the essential legislative function, is certainly the consolation. The body to which the function has been delegated as a representative character. In other words, if no guidance is provided or policy laid on, the fact that the delegate has a representative character could make no difference in principle. Then next, serial number 13. Paragraph 3. They function best when they concern themselves with general principles, broad objectives, and fundamental issues instead of technical and situational intricacies, which are better left to better equipped full-time expert executive bodies and specialist public servants. Parliament and the state legislature have neither the aim nor the expertise to be involved in detail and circumstance. Then nor can Parliament and state legislatures visualize and provide for new, strange, unforeseen, and unpredictable situations arising from the complexity of modern life and the ingenuity of modern man. That's the raison d'etre for delegated legislation. That's what makes delegated legislation inevitable and indispensable. Parliament and the state legislature endowed plenary power to legislate upon any of the subjects entrusted them by the Constitution, subject to the limitations imposed by the Constitution itself. The power to legislate carries with the power to delegate. Excess delegation may amount to abdication. Then, few lines later, legislate it must by laying down policy and principle, and delegate it may to fill in detail and carry out policies. The legislature may guide the delegate by speaking to the express provision, empowering delegation, or other provisions of the statute, the preamble, the scheme, or even the very subject matter of the statute. That's what I've been trying to tell your lordships. The very subject matter of the statute, the preamble, introduced in 2016, and look at the scheme of the act. So will you say RBI should be denied a certain authority in the monetary policy, currency management, and so on and so forth? So if guidance there is, wherever it may be found, the delegation is valid. A good deal of latitude has been held to be permissible in the case of taxing statutes. Same principle, a generous degree of latitude must be permissible in the case of welfare legislation, particularly those statutes which are designed to further direct the principles of state policy. Give me the... The first page, the Federal Energy Administration versus so-and-so. I read out about the President issuing a proclamation following the Secretary of State's investigation. I would put it like this, if I can paraphrase it. The emphasis of the US case in the case of Federal Energy Administration is that even the words as he deems necessary, the word as he deems necessary was not read to mean there was improper delegation lacking guidance. The interest of national security was itself deemed to be sufficient factors in guidance. It can come back to you. 1978, please hand over to the court. Please. We have both the Rajya Sabha and the Lok Sabha debates. The 3-page one is the Rajya Sabha debate. Kindly turn over to Justice Nagarathna got it?
Yes,
Sorry.
Sister Lok Sabha.
Yeah. Yeah. There's a running number there at the top here, 146. I'll be kindly turn over to page 148. That's the next page. And before I read that page, please come to page 154, the minister's statement, page 154. Lords, have you got it? Sri H.M. Patel, sir, I am glad to say that this bill has a limited objective as already stated. I was asked whether the government had any particular motive other than that which is stated. I do not see why there is any need to look for motives other than the objective for which the ordinance was promulgated and the bill is brought before the House. It is because these high denomination notes, that is 500 and 1,000 at the time, were being utilized for financing illegal transactions or for illegal purposes. It is clear that this had a limited objective. The total number of these notes in circulation is worth rupees 145 crores. Just hold on, we are going back there 1978. Therefore, the quantum was certainly less.
145.
The total number of notes in circulation in this country today is over rupees 8,000 crores. Therefore, quite obviously, this could not have ever been designed to achieve anything of the nature of trying to attack even the black money problem, etc. It had no such objective. So it had the objective that is mentioned here. To pick up the 46 Act. 46 Act. Then kindly turn over to page 140. What is it? 1946. Here. So the 3-page, 4-page. Just begin.
Circle.
The paragraph. I may also point out in this connection, there's almost a universal demand by experts for the demonetization of 100 rupee notes.
Where are you reading? Where?
Page 140, the second page.
148. Page 148.
148.
The page number is at the top, 140.
Yes.
The second paragraph on the right hand side. I may also point out this connection, almost a universal demand by experts for the demonetization of 100 rupee notes. If any impact were to be made on unearthing the hoarded money and if inflation were to be arrested, the Finance Minister of Tamil Nadu and Chief Minister of Tamil Nadu were among those who were emphatic about the need for the demonetization of 100 rupee notes. But that has not been done. Demonetization of such notes would have given the shock of their lives to the black money operators. So an opportunity had been lost for putting new life into the economy by checking these evil forces. I admit the administrative complexities would have been tremendous, but the beneficial effects on the economy would have been far more tremendous. It is not beyond the organizing capacity of the central government to have brought in such a measure and implemented it successfully in a thoroughgoing manner. If that was a level of debate in Parliament in 1978, I'm sure the Parliament did not think that the three evils to be addressed were illusory and false. Now turn over to the next Lok Sabha debate. Page 640, 646. The page numbers are available at the top of 646, the second paragraph, and the right hand side again. Lords have got that page? Very good. The ordinance was promulgated on 16 January 1978. We have to see the relevant figures and also as to what was the effect of demonetization in our economy and also the currency circulation. According to the figures that are given by the Honorable Finance Minister, high denomination notes worth about 140 crores were in circulation, 1,000 rupee notes worth about 125 crores. And it will be not more than 0.61%. Therefore, this will not have any great effect on the economy. This House very well knows about the report of the Vanchu Committee, which recommended in 1970 that even the 100 rupee notes should be demonetized to curb black money. But unfortunately, the bold step taken by the Janata government did not include the demonetization of the 100 rupee notes. There are a number of defects, etc. And then the last part of that particular paragraph, I request the Honorable Finance Minister to see that some steps are taken to demonetize the 100 rupee note, because only then we can curb black money, which is running a parallel economy in our country furthermore. And then another member at page 651. In the middle of that page, on the left-hand side, the sentence beginning, it is a serious matter if this happens. Then the next paragraph, it is said, Lordships have the paragraph, in the left-hand side at page 651.
It is said.
It is said that black money operates through 100 rupee notes.
Yes, bro.
Very clever people have changed their 100 rupee notes into 10 rupee notes. What proposal does the minister have to curb and control black money? In this connection, an isolated suggestion of demonetization of 100 rupee notes will not help. It is only one of the processes. Way back in 1978, at a lesser level of black money operation, this is what the parliamentary debate talks about. So I would appeal to the minister that he should follow the principle of demonetization by curbing the generation and expansion of mismanagement of black money. I hope he'll come forward with concrete measures with purpose. Now we are in the year 2022. 2014, a white paper was placed before the parliament. That white paper is on record. It talks about the need to balance the impact on people, the poor and the underprivileged would suffer hardship where a cash is to be curtailed. At the same time, look at the larger objective. It talks about balancing that. So in 1978, if Parliament was saying you should have demonetized the entire currency, 100 rupees including. So we are talking about 86.4% because it has become pervasive. These two denominations are the major currencies today, denominations. So either somebody will come and say, why 86.4%? Why not 10%, 20%, 30%? So you will have a calibration where the least impact factor should be taken into account and then find out whether the least impact factor would serve the purpose of addressing these evils. Therefore, the question of percentage is hardly the point to be taken into account. The question is if the denominations in question are the denominations to be accounted for, dealt with for the purpose of addressing this evil, the court will definitely leave it to the policy-making authority to calibrate them and then deal with them. As I said, now the impact is seen for about 5-6 years, how it's happening. So therefore, I would appeal to the court before making some final conclusions that don't look at it in isolation. As this parliamentary debate says, it is not only one of the processes. See, one of the processes, like we are looking at a huge mountain, and 26 is like a sledgehammer. And the sledgehammer, you use a mountain to knock out a mountain. Give a little more strength to the sledgehammer, don't weaken it. You may have other occasions where other demonetization, we look at the currency management. So internal monetary stability. State actors floating in fake currency all over our country. So this can't be calibrated at all. You can't have a scanning machine by which today I have 100,000 notes on fake currency. Tomorrow I will have more. I mean, where do you have this kind of thing happening? Therefore, we are touching the life nerve or the monetary policy of a country where one important step was thought to be necessary Of course, as I said, this balancing would have had all kinds of issues. The court would, at the least, address those balancing issues, find out what remedial measures are possible within the framework of the law. So finally, on the question of this cutoff date, we said once you move the cutoff date, then of course the stability, the integrity, the internal integrity of the whole decision-making process will also be diluted. So that's why we find considerable difficulty in accommodating people who had very genuine grievances. Somebody put 30,000 rupees in his paper book and could not get it. So therefore, the government should formulate a policy where within a period of 1 year, let us say, all possible exchange processes will be completed, and then we would be able to have a watchdog at every bank and outlet where this exchange can take place and see that people do not really get their back money and fake currency exchange. So what is that we are talking about? I just hand over to Lordships a few references to judgments. But I must also address this question as to whether the difference between 4678 and 2017 will have any bearing on the question of judicial scrutiny. If on the one hand it is argued that in 46 and 78, Parliament went into action mode and he did not look at 26, he did not ask RBI to take any steps. And you could have followed the same measure. The two important objectives in 46 and 78 were very different. Today we are in an entirely different globalized economic and other domestic situation. So please don't compare a 46 and 78 with what's happening today in the economic situation of the country. And those three evils which will continue to, grin at you and say, look here, I'm your challenge. Therefore, to say that never use 26, you should not have used it, go to Parliament. On the one hand, please look at what Parliamentary debates in 78 said. You could have used it much more. In 78, Parliament says, why only 500 and 1,000? You could have also demonetized 100. Spread it little wider. If today, without going to an initial parliamentary process, if that wider net is stretched and put into action mode, and later Parliament says, yes, I give my approval to the 26/8/11/2016 notification, then Parliament has effectively come into a deliberation. It has approved it. Therefore, this distinction, I think, would be a distinction that the court will not enter into. And if it all entered, for what purpose? Will the court say you have chosen a wrong mode of action for addressing these three evils? Address it only through Parliament. I'm not sure the court would enter in that kind of suggestion to parliamentary procedures and practices. And the plenary exercise the power by the Parliament. You can copy of this. Academic. Constitutional practice in US Supreme Court. I only picked up 3 judgments for Lordship's notice. And it can happen in a number of circumstances. The last one is that. Kindly turn to page 9 of this note. It's again a very short judgment. At least some paragraphs have been set out here. This action, even though it's called per curiam, this is how the opinion runs. This action was commenced to restrain certain persons from proceeding to incorporate the village of Tarrytown under the General Act of Legislature authorizing the incorporation of villages. The persons made defendants are those who signed the notice required, and the officers of the town would be inspectors of the election. A temporary injunction was obtained, which is resolved, and the election was held, and the majority votes determined in favor of the incorporation, and the proceedings for such incorporation have been perfected. Village officers chosen, and the corporation is in operation. By a supplemental complaint, these facts are set up, and judgment demanded that all these acts be declared null and void. The grounds of the action are that the statute was not complied with, and the statute itself was unconstitutional. We do not deem it necessary to determine whether the action is maintainable as it originally commenced. As it appeared upon that trial and is presented of an appeal, no effectual judgment can be rendered in it. The act sought to be restrained have been consummated, and from a project to incorporate a village, the village has been incorporated. The defendants are not necessarily a proper party to the action upon so-and-so. The village itself and the trustees are now exercising the franchise or the necessary party to the action, and the injunction restraining the defendant would have no practical effect upon the corporation. We do not deem it proper, therefore, to express an opinion upon the points presented involving the validity of the statute or the regularity of the proceedings under it, for the reason the decision could not be made effectual by a judgment. The general term might perhaps reverse the judgment and directed the proper parties to be brought in, but it is not the province of the court to do so. Besides, so-and-so, a real act nature of quorum to an appropriate, if not the only remedy. The one broad principle, as I said, the US courts have always been following, and I think this principle is worthy of acceptance in this matter. What else do you want to say? That analysis of the doctrine of proportionality. Sometimes it becomes useful to just look at it. I don't want to engage your lordships. It only says sometimes there is, as I said in the morning, unconstrained moral reasoning will always something which come in the minds of the court in dealing with certain set of matters. And then they are not wholly out of point. But when an unconstrained moral reasoning in certain areas comes into focus and it permeates the decision-making process, that could be some kind of issues. So this small critique only looks at is how various thinkers look at it and how there can be a problem in comparing incomparables. So very often proportionality enters into comparing comparables. Then we enter into comparing incomparable, there could be a problem. So the case on hand is this, where the larger public interest is moving towards a wide range of economic and policy transformations on the one hand. Can you compare it with, certainly, nobody says the hardships are to be belittled. But if you can compare it to the hardships, if the hardships are the only factor to be addressed, the only relevant factor to be addressed, then one wonders, how would you design this whole policy perspective? That is where the proposed test will not be applied. The court then being asked to enter into a designing of a policy perspective, either to address these evils or not to address them at all. I'm not very clear. Again, to come back to only Article 13, it says laws which are inconsistent with fundamental rights to the extent of inconsistency can be declared to be void. That's why Part 3 occupies an important field in our adjudicatory process. But minus stands Part 3 issues, or under a very attractive propositions of 14, 19, and 21. The court is being called upon, as I say, to design a policy framework which will be flawless, which will be completely out of any blame, things like that, and so on and so forth. I submit to the great respect, the court will not enter into that. And my learned friend will address on the question of RBI and its role in certain respects. And I'm extremely thankful for lots of kind wishes. And I must read para 195 as my friend wanted me to read and give my comment on that and the cryptocurrency judgment. Para 195 at page 377. Let me read it. I wanted to read it after I thought I would have made all these submissions and come back to para 195.
Yes. 37.
There can also be, at page 377, there can also be no quarrel with the proposition that banking channels provide the lifeline of any business, trade, or profession. It is especially so in the light of the restrictions on transactions contained in section so and so. And currency itself has undergone a metamorphosis over the century, from stone to metal to paperless, and we also assured the digital age, cashless transactions require banking channels. Therefore, the moment the person deprived of the facility of operating a bank account, the lifeline of his trade or business is severed, resulting in the trade or business getting automatically shut down. Hence, the word now showing that larger public interest warranted such a serious restriction bordering on prohibition is heavily on RBI. Certainly, yes. I suppose I have carried your lordship through my submission, and the facts based before lordships, this has been discharged. And this, give a copy to the board. Again, this is only a list of judgments that courts will not. You give it? We give it to the court. You can copy. Question posed was, did RBI have knowledge about information about the value and volume of notes in circulation 2015 or 16? They have it almost on an everyday basis. They publish it. There are annual reports published. And this is as regards the 2015, 16. So 15, 16. Of the Central Board of Directors and the working of so and so for the year ended June 30, 2016. And in the next page, we have the trends in currency, where at the top, bank notes in circulation at the heading, and the table gives a complete figure of the total bank notes in circulation or various denominations.
Venkataraman, they are the ones who issue notes.
That's right. To say that there is no information, and what kind of information, I'm not very clear.
Well, I didn't say RBI did not have information. I said that the information placed before the RBI board when it met.
We will address this.
It's still not produced any of the documents for them.
Milord, this last bit, Milord, which my learned friend is doubting whether the RBI was aware of this, is a published data, annual reports of RBI. To say that is a with a small bit of housekeeping arising out of what happened in the morning. Milord, the 9 matters relating to district central cooperative banks, which are not referred to the Constitution bench. That list, Milord, we have prepared. Now, Mr. Seshadri Naidu, Milord, had sought the withdrawal of one case relating to district central banks. Milord, it was effectively objected to by Ms. Manjula Gupta on the ground that there is an issue in the present matter, question 9, which deals with it to some extent. Now, Milord, we have found that there are other matters also before your lordship, which are district central cooperative banks. But, Milord, that point has not been argued by any petitioner before your lordship. Milord, it is a separate issue. It has its own facts. So, my lord, if your lordship wishes to hear arguments on it, my lord, petitioners must at some stage address. Or we are, my lord, there is no difficulty if this entire question of DCCBs is kept out of the constitutional
What
bench.
we are also proposing, Mr. Gupta.
That's all right.
We are
But
also proposing, we will, at the end, we will say all other questions shall be addressed before the,
by the
this is what
by
we are
other
proposing to
yes,
do, actually.
in which case, my lord, I should. Yes.
Please continue.
Yes, ma'am.
What is the context in which that question has arisen in order to detag those cases?
My lord, I'll tell your lordship the entire background in a minute. My lord, there are these district central cooperative banks, which, my lord, are below, my lord, the state cooperative. Now, my lord, they are actually cooperative societies. They are not banks in the true sense of the word within the meaning of banking company. So, my lord, there was a question as to whether they must function as a bank does in receiving deposits from their constituents and handing it over to the Reserve Bank, as all banks were required to do. My lord, there was some confusion on the 8th. This confusion was resolved on the 9th by saying that though you are strictly speaking not banking companies, but you are now told that you must do what the other banks are supposed to do. My lord, what banks were told to do was they had to reconcile their accounts on the 9th. My lord, the 8th was the notification. On the 9th, my lord, it was a bank holiday declared specifically for the purpose of banks reconciling their books and coming to a conclusion as to the amount of cash that they were holding on that date. Then, my lord, on 10th, they were supposed to give a declaration of the amount that they were holding and also, my lord, to deposit the amount. Now, this was to fix the opening balance. Because if that opening balance was not fixed, any amount of cash could have been accounted for as opening balance by saying that, oh, we already had this in our hands on the 8th. My lord, DCCBs, my lord, are unfortunately not fully regulated. They are not under Reserve Bank regulation. There is some supervision of, my lord, NABARD, which is a subsidiary, my lord, agricultural bank, my lord. It's a subsidiary of Reserve Bank of India. Some supervision is there, but not to the extent at all that other banks are. So, my lord, it became a rather, my lord, it became something of a problem, my lord, in this process.
Cooperation is a state subject.
My lord, cooperatives is a state subject. Then, my lord, so what happened then was that some of them, my lord, did not disclose that. They are before this court saying that we should not be asked to disclose. Secondly, my lord, on 10th to 14th.
No, actually, what has happened is
Yes.
we have tabulation of the prayers made
Yes,
in all the writ petitions.
yes,
We'll tell you the statistics.
Lordship.
There are 40 writ petitions.
Yes, my lord.
There are 12 transfer petitions.
Yes, my lord.
6 special leave petitions.
Yes.
And 1 transferred case.
Lordship.
Out of them, what was listed originally at the instance of the district cooperative banks
Yeah.
were about 6 writ petitions. Some of those writ petitions, only 1 or 2 of them challenged the virus of 8/11/2016 notification.
Correct.
Therefore, they form part of the batch, though the petitioners are district cooperative banks.
Lordship.
Other district cooperative banks, the prayer was only to the limited extent that we should also be given the transaction right to receive the specified bank notes and return them.
Yes.
So that question, whether that question survives at all now, because the question of now receiving the specified bank notes, the only prayer, some of the district cooperative banks, the only prayer was, we must be allowed to transactional rights. That transactional rights cannot now be granted to them.
My lord, may I just
On the specified bank notes, on the
Correct.
specified bank notes.
Right. My lord, may I just add one thing to that? They were, my lord, there was a situation whereby they did transact between 10th to 14th of November.
That's right.
Now, when that happened, they were asked to stay their hands. They would be given instructions later on. Those were the instructions which were given, my lord. A window of opportunity was opened to collect that money and give it to the RBI in June and July of 2017. No, yes, you're right. Not to collect, quite true. Not to collect. Whatever has been collected between 10th and 14th can be deposited with RBI in June and July. So, though whatever was done by June and July. Now, if somebody has not taken the advantage of that window of opportunity, there can be no question. And, my lord, there is no, they did not have, my lord, the power to receive cash after the 14th. So if they have done that, they have done that illegally. So therefore, my lord, there's nothing to be done about that either.
My lord, may I just clarify?
And only one more thing before my learned friend starts. My lord, in my record, my lord, at page 33 of one of our affidavits, which is in the compilation, we have noted, and your lordship, my lord, has the statistics, my lord, that there were 2 writ petitions or more, my lord, as your lordship has said, but there was also, my lord, 3 SLPs. The SLPs came from the state of Rajasthan, where, my lord, this similar prayers had been made. So, my lord, this is not even, my lord, what Mr. Divan's clients, my lord, is facing, because that is the question of an individual or an entity or a constituent of a bank going to the bank with their currency and that being accepted. That's a different thing. Now, the DCCB is the bank surrendering the currency to the Reserve Bank of India. Now, therefore, my lord, there are some which are in this list. There are some which is outside. My lord, your lordship have framed one question, but my lord, if your lordship wishes to keep the whole lot out, all I will do is, my lord, collect the particulars of the ones which are before your lordship today and hand it over to your lordship's officers, so that if your lordships wish to keep that apart, then the whole lot should go out along with the question number 9. So the DCCB issue will therefore not be, my lord, before the Constitution bench at this point.
May I just clarify, my lord, it's not the DCCB only, but it's the primary. Manjula ji was making submission on primary agricultural credit societies, my lord, at the primary level. What happened with them was that on the 8th, whatever cash they had with them on the 8th was not taken either by the DCCB or and they could not open their bank accounts in any other nationalized banks. So the cash that was left on 8th is the only one. That is what is an issue before in those cases, my lords.
No.
The cash left on 8th because DCCB had instructions to accept only from the individuals and not from the institutions. So these were institutions that did not accept the cash which was left with them because of sale of fertilizers or some deposit that were made by the individuals in the society. Some societies have 6 lakhs cash, some have 8, 11, something 16, something like that, not more than that. It is only about the cash left on 8th evening, not of 9th, 10th, or because 10th and 14th and others were taken care of by it's only with regards to the 8th that the issue.
We will deal.
Just one line, my lords.
Huh.
The issue that would be before my lords would be whether it is reasonable not to allow us that the cash that we are left with on the 8th,
Huh.
being DCCB not allowed to accept from institutions, we had only our accounts were only with the DCCB. We could have deposited only there. And since nobody was there to accept it, those cash is still left with us. And therefore we are before your lordship.
All right.
That is
Milord, the short answer, Milord, if your lordships are interested at this stage, everybody was allowed to deposit. They were not allowed to deposit in DCCBs. They could have gone anywhere else and deposited.
That is exactly the case, my lords. We did not have accounts in any other nationalized banks. No nationalized banks at that point of time was opening fresh accounts, my lords.
I think we don't propose to go into all these factual aspects in this case.
No, it's only the reasonable, my lords.
Please listen to us. It is not that you are remediless. We will leave it to the division bench, or two-judge bench, to decide all these factual aspects and including the whatever you are suggesting. And I really don't know whether the Supreme Court is a proper place for you to decide these factual aspects.
As it is, my lords,
See, let us not lose focus on the important constitutional questions. Let us concentrate on that. Let us not deviate from that.
Lordship.
Let us not deviate from it.
I just wanted to bring it that.
All right. Anyhow, we are not proposing to answer all these questions. These are all more on facts. Let us focus on the constitutional points raised here. We will answer that.
Why I'm saying it is important, my lords, is the RBI or the other institutions are trying to brush us aside, saying.
It's all right. You can argue. You can argue all those things, after before the two-judge bench. You can argue all those questions.
What I just want to place before my lord's consideration is that, my lords, all these submissions that we have got sufficient opportunity is not right, in the sense that we all are left with the cash on 8th evening. That opportunity was never granted and we could not have done which I.
All right. We have understood. Yes, Mr. Gupta.
Now, my lord, coming back to the main issue, what I have done is, my lord, I have written down all the propositions which, according to me, my lord, are relevant. Now, many of these have already got addressed by the Attorney General, my lord. So, therefore, I will not be troubling your lordships with them. In some, my lord, I will supplement a little bit. But first of all, my lord, if your lordship permits, my lord, me to place this 2-page only. These are propositions which, my lord, to my mind, my lord, covers the issues which have been raised by the petitioner. First one is the withdrawal of all series of 2 denominations, that is 500 and 1000, is well within the jurisdiction and powers conferred upon Reserve Bank of India by Section 26(2) of the RBI Act. Our propositions. My lord, I haven't put it as a question. I'm putting it as an answer. So, my lord, the first question is whether 26(2) covers what has been done in this case. That's number one. Number two, the submission that unless phrase any in section 26(2) is read as some, then the power conferred by the said section becomes unguided, uncanalized and arbitrary, and that is without basis. That proposition is without basis. Then C, it is not correct to say that the process under 26(2) has not been followed in the present case. The procedure laid down has been followed and the process cannot be criticized on the ground of any procedural lapse on the part of RBI or the central government. So therefore, my lord, the first two deal with the interpretation and constitutionality of section 26(2). The next one is, my lord, whether there is any procedural impropriety, which is well within, my lord, judicial review powers. Then comes, my lord, the arguments which relate to, my lord, actual judicial review of the decision. D, the decision to recommend and the decision of the cabinet to accept such recommendation is not subject to judicial review. That's our, my lord, contention. Then, my lord, in this sphere of economic policy making, the Wednesbury principles are of no or little use. The proportionality principle also cannot be applied to the judicial review of economic policy. My lord, I will, my lord, deal with, my lord, the internet judgments in this context. Then, my lord, without prejudice to the aforesaid, the petitioners have failed to establish that relevant factors have not been considered or that irrelevant factors have been taken into consideration. This is on the merits of it. Then it is extremely important. I have kept it separate because this was a suggestion from the other side. It is extremely important that no restrictions are placed on economic policy making by RBI or the government of India by laying down guidelines, my lord, in a court. Because, my lord, that in the judgments your lordships have noted that it is impossible even for the legislature or for my lord, the government or RBI to envisage everything which may happen. So my lord, when that is so, to lay down my lord, judicial guidelines, my lord, would be extremely my lord, dangerous in our respectful submission. Then my lord, H. This now deals with my lord, the SBN Act. I'll call it my lord, the SBN Act, because that's the act which came in 2017. The SBN Act has given relief to certain categories of persons subject to verification by RBI. Individual cases of hardships that have not been provided for in the Act cannot be gone into. Milord, RBI cannot, Milord, go beyond the Act also. Milord, I'll try to satisfy your lordship. Then the submission that section 4 of Milord, Act, it's Act, Milord, not Article, I'm sorry. Act 2 of 2017 is unconstitutional, is without any basis. And finally, my lord, it is well settled that the courts cannot issue futile or academic writs. It is also well settled that it does not issue a writ if it has become infructuous, and declaratory relief in such cases will not be given if it involves factual adjudication. Now, my lord, declaring a law to be unconstitutional is a declaratory relief which can be given at any time. But my lord, to say that look into the facts of the case, judicially review based on the facts, and hold that that particular decision was arbitrary or whatever, that is an adjudication on facts. Once, my lord, that decision is not to be reopened, after that, my lord, it should not be adjudicated at this stage, my lord, is what I will try to show. Now, my lord, I'll go pretty fast, my lord, because if I come back to A, my learned friend, my lord, has already taken your lordship or given your lordship, my lord, a list of the cases. My lord, we'll also file a written note on all this, my lord, by tomorrow or day after, my lord. Your lordship has been shown that there are judgments of this honorable court which says that any usually means in common parlance, any or all. Now, I just want to add two aspects, my lord, to the argument. The judgments are there, my lord, the same judgments which and in fact, my lord, 3 of them, my lord, we have put in a compilation which we have made, which we are handing up to your lordships in any event. The first 3, my lord, are on that issue. Now, I want to add only 2 things here, my lord. The first is that my learned friend's contention is that it should be read as some specified series or some specified denomination. Now, what is that sum? Is it 1, 2, 3, all minus 1? Suppose all is 20, then 1, 2, 3, 4, 5, 6 up to 19 satisfies the definition according to my learned friend. It is only if it becomes 20 that it does not satisfy the section. So, my lord, to say that any means sum is, my lord, actually creating confusion in that section. The next question will be, what does sum mean? How many? Can I demonetize half the money? Can I demonetize 25% of the series? Can I demonetize 75% of the series? My lord, it just can't be. So, my lord, that's why any means any and all of that. In fact, my lord, my lord mentioned this. There might be situations where all the money has to be demonetized. My learned friend, Mr. Chidambaram, has actually given what, according to him, are the 2 legitimate, my lord, instances where demonetization will take place. And one of the 2 examples that he has given is when the currency of the nation has lost all its value. When that happens, you will demonetize the whole currency. You won't leave a little bit of currency there. So, my lord, there your lordships are being invited to take away that power which permits the central government on a recommendation of RBI to advise that the entire currency has to be withdrawn. So, my lord, this is one aspect, my lord, which I wanted to point out. The second aspect which I want to point out is, my lord, your lordships have taken a decision in many judgments as to the role that RBI plays specifically. And even in the internet judgment, my lord, your lordship has dealt with it in great detail. And one of the aspects of the way your lordship has looked at RBI's powers is that because it is dealing with monetary policy making, therefore it should be, all its provisions should be given wide amplitude. And my lord, for this purpose, my lord, if your lordship will only permit me to place this the source case, there is the first time that this honorable court, my lord, dealt with the Reserve Bank of India's powers is, my lord, Joseph Kuruvilla. And, my lord, in my compilation, my lord, I put it at item 5. And if your lordship permits, my lord, I'll just take your lordship through one or two passages in that judgment. In the compilation, it is at page 162. My lord, the citation that I have given is, my lord, from a online web edition, my lord, which I hate, my lord, handing up to the court, my lord, but my lord, all our juniors prefer it because it's the easiest one to access. My lord, in any judgment, the easiest copy to lay your hands on is the SCC online web edition. That does not have a head note. And that, of course, refers to the other paragraphs don't match. We are not even sure that everything that is written there is correct. But, my lord, this is the easiest one to get hold of. Therefore, my lord, when I say we want to place this judgment, they have all given your lordship, my lord, the SCC online web edition.
Actually, SCC paragraph don't tally with the SCR or our AIR.
Yes, my lord, and SCR doesn't even have a paragraph. We have to go by placitum there.
But there is a judgment of this court which has appreciated, There is a judgment of this. This very question came up before this court.
Yes, yes.
Of SCC only.
My lord, your lordship knows that at one stage, the Supreme Court never accepted any citation other than SCR. But then, my lord, SCR fell behind the times. Then there was no option.
No, see, for instance, people like us, we put paragraph numbers properly.
Yeah.
SCC, in order to claim copyright, they alter the paragraph numbers.
Oh my God.
And the head noting is an incentive for people to read.
Yes.
Otherwise, 200 pages.
But now, I'm sorry to be wasting time, my lord, but
The copyright case in the High Court.
Yes.
And in order to get over that judgment, they started introducing head notes and then prefatory notes.
Correct.
And all kinds of footnotes also.
No, one paragraph is split into 4 paragraphs.
Therefore, the paragraph, your lordships are right. Your lordships appreciated SCC, not SCC online.
Okay. Yes.
in fact, now, my lord, we are finding that SCC head notes are often, my lord, covering most of the judgment. The head notes are no longer, my lord, as pithy as they used to. Also to get over copy.
No, in one of the cases, the head notes ran to 183 pages.
That's correct, my lord. They were just extracts of large parts of the judgment. Kuruvilla. It's at page 162, item number 5. To be absolutely, my lord, proper, the citation that I should give your lordship is 1962 supplementary volume.
Jaideep Gupta, before
Yes.
that,
Yes.
I just want to put it, let us be focused on the argument of the other side.
Yes.
See, their prime, they have no problem of your, functioning and all. There is no problem. The focused question is, central government, Union of India and RBI have not followed 26(2).
Yes. So
That is the question.
that's the third proposition, my
Let us
lord,
be
which I'm
focused
dealing
on the question.
with. But, my lord, my learned friend, my lord, has also, my lord, sought to argue both the first two questions, that you should give a limited construction to 26(2), and if you don't give a limited construction,
True.
then it becomes.
That also emanates from 26(2) only.
That's right. It's emanates from 26(2).
Yes.
Now, please see, my lord, para
And
14.
you have not followed the procedure prescribed in 26(2). That is the other question they have.
That's the third question.
Recommendation is.
That's the third question. Yes.
Recommendation
Right.
part.
I'll come
Let us focus on the questions,
Yes, my lord. That's why, my lord. That's why, my lord, I have given your lordship all the questions that I intend to address your lordship on.
All right,
And, my lord, some which I do not wish to address because the learned attorney has already said.
Yes.
Now, the Reserve Bank's powers came for consideration for the first time of the Supreme Court, my lord, in this judgment. and kindly come to paragraph 14 of this report, my lord, at page 167. And here I'm only showing this to your lordship because here also it was argued that it was uncontrolled and despotic and uncanalized powers were being given to the Reserve Bank.
Yes.
Now, kindly come to 16. Before we consider the arguments of two sides in detail, we wish to say a few words about the position of Reserve Bank of India in the financial affairs of India and also about its place in the scheme of the law. Well, I am relying upon these passages to my lord, argue that the widest amplitude should be given to section 26(2) and that there is nothing unguided about it. These are the two propositions, my lord. The Reserve Bank of India was established in such and such, my lord. Then the history of it is set out. Then para 17. The functions of the Reserve Bank are generally indicated in the preamble as the regulation of the issue of the banknotes and keeping the reserves with a view to securing monetary stability in India and generally to operate the currency and credit system to its advantage. But to enable RBI to function in this manner, it had to be given other powers so that it may function effectively as a central bank. To this end, the Reserve Bank was given the right to hold cash balances, a right to transact government business, which was also its obligation, and to enter into agreements, etc., etc. And then they could control the banks. Then 19, on the next page, the above analysis of some of the provisions of the RBI Act shows that the RBI has been created as a central bank with powers of supervision, advice, inspection over banks, particularly those desiring to be included in the second schedule, etc., etc. Then just see, my lord, the last 5-6 lines. No doubt the members of the board are subject to removal, but neither integrity nor efficiency is secured only by such guarantee, and we have no reason to think that the Reserve Bank acted in this case or acts in other cases under pressure or from oblique motives, as was pointed out in another tribunal, etc. Please see this language of that extract, All India Bank employees. If it was not the Reserve Bank of India, the only other authority that could be entrusted with the function would be the Finance Ministry of the Government of India. And that department would necessarily be guided by the Reserve Bank, having regard to the intimate knowledge which RBI has on the banking structure of the country as a whole and of the affairs of each bank in particular. The position of RBI being such, as we have stated from the Reserve Bank of India, the next thing is to inquire as to its powers under the Banking Companies Act, etc. And my lord, if your lordship comes to page 171, para 25, last two sentences, 171, para 25, last two sentences, there is hardly any provision where the Reserve Bank's judgment is not made final vis-a-vis a banking company, except rarely where an appeal to the central government can lie. No useful purpose will be served in referring. Then, my lord, your lordships may, my lord, look at para 27, etc. I am not troubling your lordship with anything else here. Para 46 at page 179, and I'm only taking your lordship through all this because this is the source case. In the present case, para 46 at page 179, in the present case, in view of the history of the establishment of Reserve Bank as the Central Bank of India, its position as a banker's bank, its control over banking company and banking in India, its position as the issuing bank, its powers to license banking companies and cancel, it is unanswerable that between the court and the Reserve Bank, the momentous decision to wind up a tottering or unsafe banking company in the interest of depositors may reasonably be left to the Reserve Bank. No doubt the court has also, given the time, performs this task, but the decision has to be taken without delay, and the Reserve Bank already knows intimately the affairs of banking companies and have access to their books. If the court were called upon to take immediate action, it would almost always be guided by the opinion of the RBI. It would be impossible for the court to reach a conclusion unguided by the Reserve Bank if immediate action was demanded. But the law which gives the same position to the opinion of Reserve Bank is challenged as unreasonable. In our opinion, such a challenge has no force, etc. So therefore, your lordship sees, my lord, the position that your lordships have, my lord, acknowledged as far as the Reserve Bank is concerned. So if this is the position, my lord, and the second judgment, my lord, which I won't go into just now, is item 4, Peerless General Finance versus Reserve Bank of India, which your lordships have referred to in the internet case, will show, my lord, that when you construe a section which confers powers on the Reserve Bank of India, your lordships do it to give a wide power to the Reserve Bank of India, because these are matters which the Reserve Bank is best suited.
On the contrary, Mr. Gupta, their argument is otherwise.
Yes,
According to Mr. Chidambaram, everything to do with currency
yes,
has to be with RBI. RBI has the supreme role in that.
yes,
And therefore, this decision for demonetization
yes,
should have emanated from RBI.
correct.
But it has now come in a reverse direction. He has argued on the decision-making process
That's
that within 24 hours, the government writes a letter to the RBI, the RBI
Correct.
convenes a meeting of the board,
My lord, that,
takes a decision within 1 hour, the
Yes.
Prime Minister announces it. That's
my lord, that's, my lord, if
therefore, the basic condition is that the procedure is not in accordance with 26.
is not in accordance to. So therefore, my lord, that is for him, my lord, it is an argument in the alternative, because in the first instance he says that you don't have that power at all. In the second,
The government doesn't have that power.
Government, not RBI.
no, RBI does not have the power to recommend, and the government does
No.
not.
On the contrary, he says that it is the RBI who has the power to recommend. And the recommendation ought to have come from the RBI, not the other way around. That is
No,
what
no,
his
my
position
lord, I'm only subject to my correction from my learned
is.
friend.
Chidambaram-
Any, according to him, is only some. So therefore,
So there are three.
That is one of the arguments.
yes, of course, one of the arguments,
First argument is that read any in a limited manner.
limited manner, yes.
If you can't read it any in a limited manner,
Then it will become unconstitutional.
26(2) is vulnerable to vice of excessive delegation.
Yes, correct,
And the third one
yes.
is that the procedure as prescribed under 26
Has not been followed,
has not been followed.
yes,
And therefore, though he also agrees that we cannot sit in an appeal over the decision,
yes,
but since the decision making process is flawed,
yes. Therefore, there is a procedural
it
impropriety,
is liable to be
quite right.
interfered with.
I have no difficulty, my lord, your lordship.
I think these are the three
Yes, correct,
positions.
correct, my lord. So therefore, I now move on to the unguided and uncanalized power aspect, my lord, and I just want to say one thing about it, my lord. No, before that.
Central government via notification.
Yes,
It is possible for the parliament also to take the legislative route,
yes.
but that is not the only route.
Well, that is,
I think that will.
well, that is precisely my
That
argument.
argument must be understood, I think. It is not that parliamentary legislation is a mandatory way of doing demonetization.
Your lordship is right. What I said was, there are two ways in which demonetization can be done. One is the 1946 and 78 example by legislation, where the RBI doesn't come into the picture at all. Parliament does it, and I can challenge it on the violation of 1419. That route was taken in 46 and 78. The other route, as my lady said, go through 26. But 26, I said, the process must start from the RBI. So there are two routes. I'm not questioning the two powers, two sources of power. One is Parliament by plenary legislation. One is under 26. And 26, my Lord Justice, I summarize my arguments 1, 2, 3. The first argument and the second argument. But the most important was a decision-making process in accordance with 26.2.
Now, my lord, in the affidavit which my learned friend placed, it was stated that
Whose affidavit?
my lord, this is, my lord, filed by Miss Kamini Jaiswal, which my learned friend placed in some detail, my lord.
No, that was not argued in all this. You please focus on whatever his arguments, If something is not argued, we will not go into all that.
I'm not
Please focus on these three
I'm
questions.
not asking your lordship.
Actually, frankly, there were no, what is that argument against RBI here. It was virtually against the Union of India actually. There was nothing against you. I think you can straight away, you can accept.
On the contrary, he is pleading supremacy of the RBI in all these matters.
Actually, in the argument, as my brother said,
Yes.
was supporting you. You are belittled, you are not taken into confidence, etc., etc.
Well, I'll just read one passage from this affidavit which my learned friend placed. It is submitted that Parliament has the same power in 1946 as in 1978 as in 2016. Nevertheless, Parliament concluded that the demonetization that was intended could not be done under 26(2) of the RBI Act and required separate legislation. In 1946 and 78, Parliament intended to declare all series of a specific denomination. Since that power was found to be not available in Section 26(2), Parliament passed a separate law on each of these two occasions. My learned friend's argument was, if I recollect, he said that why else? Why else would I legislate? If I had the power under 26, why else? Why would I go to legislature? Milord, there is a very simple answer to that. And that answer, Milord, is now been borne out by the records which he has himself submitted. You go to legislation when the governor, you do not want to have the governor central board's opinion, when you want to bypass RBI. And Milord, in both those two cases, your lordship has seen.
Governors were against demonetization.
Your lordship has seen that. In both those two cases, Milord, the Reserve Bank did not appear to be in favor of demonetization. Therefore, Milord, legislation. That's the reason. Not that they had intent, they knew that they didn't have the power under 26. So, Milord, I close this point, Milord, here and move on.
And also the legislation was in respect of all series of two particular.
Two particular denomination, exactly like us.
That is why notwithstanding.
Notwithstanding, quite right, Milord. Notwithstanding 26, etc. And Milord, there are small arguments here, Milord, that if you go by way of legislation, then there is a debate. There is no debate because in every situation, you go by way of ordinance. You have to go by way of
I want
ordinance.
to only answer one question perhaps.
Yes, yes.
Whether you are taken it into confidence or not, that's all by the government. Before demonetization.
Oh, Milord, that is fairly
That
simple.
is the only, that is their argument.
Right. So then, Milord, I'll move on to the third question.
Or as you read one judgment, you had some intimate knowledge.
Yes.
So, there you read some judgment.
Yes, yes.
Intimate knowledge.
Lordship.
So you had intimate knowledge without.
So, Milord. Now, Milord,
You read one of the judgments.
therefore, yes, yes, I have only placed one judgment. That is that Kuruvilla judgment.
Hidayatullah's judgment.
Intimate knowledge, because Milord, that's what the Reserve Bank is required to do. This is their job. Milord, monetary policy, Milord, is the express mandate of this Act, and monetary policy, Milord, includes currency management. So therefore, Milord, this power is given to RBI. RBI is the expert, which I'll show.
No, what I meant is intimate knowledge of demonetization, not intimate knowledge of your currency.
Milord, currency management includes demonetization. Milord, I think, Milord, the one argument which has not been made, and rightly so, is that demonetization, these three objectives have no nexus with demonetization. That argument has not been made. Because, Milord, demonetization is certainly one way in which these problems can be tackled. Whether it can be tackled well or it cannot be tackled well is a different issue. But it is definitely having nexus. So, now, Milord, as far as C is concerned, that it is my submission, Milord, that it is not correct to say that the process under 26(2) has not been followed. Milord, your lordship knows what has happened, Milord. The attorney has also indicated.
Yes, yes.
Discussion started, Milord, earlier. Discussion started earlier, but Milord, demonetization is such a decision that this discussion will always be fragmented. You will not one day open a note sheet saying that whether to demonetize. Because if you open that note sheet, then immediately, Milord, this will become public knowledge. So therefore, Milord, you will collect information from here and there. And then, Milord, somebody will put it together at some senior level, Milord. That's the only way this thing can go ahead. So therefore, Milord, the discussions, Milord, appear to have started in February. But, Milord, now we come to, Milord, what is the requirement of the section? The requirement of the section is that the last two steps in this process is that there must be a recommendation from RBI and there must be a decision by the central government. These are the last two steps. Their affidavit says that the first step is RBI, because they say that if you read section 26, it has to be initiated by RBI. That's where, my lord, the fallacy lies in my respectful submission. My lord, that was paragraph, my lord. We'll come to that. Where's that affidavit gone? You've taken it away. My lord, in the affidavit, my lord, the way that this argument came in was by saying that it has to be initiated. That is at page 8. I'm just reading. My lord.
He has argued that.
Yes, your lordship remembers. So, my lord, my respectful submission is, if you look at 26.2, it does not talk about the process of initiation. It only says that it will not end without these two. There has to be the penultimate step is a recommendation. The final step is a decision by the central government. Now, my lord, a situation like this can be initiated in many ways. It can happen, my lord, it can happen suo moto in the RBI. It can happen because of some discussion or something has taken place on an international level. It can happen at the instance of a state government. Certainly, my lord, it can be initiated by the central government, because what is happening is the central government has a problem. Black money is a problem. It's a problem, my lord, which can be sorted out through the offices of RBI. But, my lord, it is a problem which affects the nation. Then, my lord, comes terrorism. Now, RBI is not, my lord, having intimate knowledge of terrorism. Facts have to come from somewhere. So, my lord, it is perfectly normal for the central government to raise the question. What do you think we should do? And then comes a recommendation. Recommendation can go either way. Your lordship is right. We could have said no. We don't think it is right. That is what happened in the last two demonetizations. Or we could have said, and in this case, we did say that very well, it might be appropriate to do it that way. And that, my lord, goes back to the central government, and the central government then says yes. Now, there also, my lord, the central government has a discretion. If I say go ahead with the demonetization, the central government may still decide that no, we won't, for some reason, because the language is may. Now, this is the process under the law, under the section.
Even if you don't recommend,
Yes.
still the central government
My lord,
may decide to go ahead.
may decide, but it seems, my lord, that in that event, it might have to bypass RBI and might choose the legislative process. My lord, my lord,
If you read section 26(2),
yes. On recommendation of the central board, the central government may by notification declare. Now, it doesn't say, of course, what kind of recommendation, a positive or a negative recommendation. What will happen if there is a negative recommendation by the central board? The central government may do it still. That's why, my lord, the Attorney General said that because we are not faced with that fact, we are not required to finally take a position on that. That's all.
On the basis of hypothesis.
That's right. It's a hypothesis, so therefore we don't have to go that far. Anyway, my lord. Now, my lord, momentous decisions are taken in this court in a matter of minutes. Similarly, my lord, when the central board of the Reserve Bank sits, my lord, they are not going to start by taking a pen and paper and start writing down from scratch. They are, my lord, people drawn in from various, my lord, walks of life, and also, my lord, experienced members of who have gone through the Reserve Bank of India. So, my lord, they have a certain amount of information readily available. Minutes are given to them, they take a decision. So, my lord, the recommendation is the decision-making process of the RBI. That can take place.
Compare this court, with the RBI. Here we hear the lawyers in the open court and argue. And
Yes,
take a
yes.
decision.
Of course, your lordship hears us. But, my lord, that doesn't mean. No, my lord, I'm not, my lord, drawing your lordships into this controversy. What I'm saying is.
Mr. Gupta, for a miscellaneous day, we read how many days, to get ready for the examination on that day.
Very well, my lord, I won't go ahead with this analogy at all. All I'm saying is, my lord, that the time or the speed, my lord, does not itself mean that there's something wrong with the decision making. This process of demonetization, two aspects. One is, my lord, confidentiality has to be there and speed has to be there. Without it, my lord, demonetization cannot possibly succeed. It's stillborn from the beginning itself. So therefore, my lord, the speed at which this decision was taken ought not to be.
What you're saying, you were consulted.
My lord, we gave the recommendation. There is a letter of the 7th in which, my lord, they have raised the question. My lord, these are in affidavit, my lord. We are not, my lord, going anywhere beyond the record. 7th, they raised the question, and then, my lord, there was a central board met, and when the central board met, they decided to recommend. And when that recommendation went to the central government decided to act. So the process was followed. Process is followed. You cannot say that the process is not followed. In fact, my lord, there is one other canard here, that there was no quorum, or that rather we do not know whether there was quorum or not. My lord, there was quorum, we have stated on affidavit. The quorum is decided by the regulations, that quorum was met. There's no difficulty with that. My learned friend also says that there were some vacancies in one category of, my lord, members.
Quorum is, I think, 4.
Quorum is 4.
And out of that 4, one has to be among that
From one has to be from that
CC category.
C category, 81C.
8 and there were only, according to him, there were 7 vacancies.
Yes.
And only 3 were filled in.
So therefore, my lord, one of them was there in the quorum. Now the vacancy in the other 7, if it does not affect the quorum requirement, then, my lord, the vacancy aspect cannot be an independent ground, because section 8.5 says that no decision will be called into question on the ground that there were vacancies in the board. So therefore, that's also, my lord.
If the quorum was there,
Yes.
have you stated on affidavit there?
I have stated on affidavit that the quorum was there. Sorry? Yeah. Both the affidavits said so. No, I'll show. Let's look at regulation 8 and 10. That's only on quorum. Yeah. My learned friend only handed up. What is regulation 8 and 10? They deal with quorum. And I'm saying specifically that the requisite procedure laid down on the section and with...
There is no dispute relating to regulation.
Yes.
The question is whether, as per the regulation, actual members participated in the meeting. This is their point.
I'm saying that the procedure required in that regulation has been done, met,
This is what
was duly followed. We have said so.
Wow, how many members are present?
Right, my lord?
There should be no difficulty on at least telling us as to how.
Yes, my lord. There is no difficulty in telling your lordships, my lord. I'll put it on a sheet of paper and give it to you.
Whether any of those members present belong to that 81C.
Yes, there was a member from 81C as well. That's why we have said on affidavit that we followed the regulation. The regulation required that 81C member, that was followed. So, my lord, that was fishing, my lord, because my learned friend does not have any reason to say that the quorum was not met. Now, my lord, in these matters, my lord, the burden still remains with him to at least say that I know for a fact that there was no quorum. He doesn't say that either. He says, I don't know whether there was a quorum. So, my lord, it becomes a prejudicial argument only. It tries to throw the burden on me.
Satisfy your lordship.
Now, this is not correct. This is not correct.
Within his knowledge.
According to you, the presumption is that
Why is he not
Administration
placing it
decision
before your
is to be
lordship?
valid.
No, no,
And the burden is on the person who challenges the
no,
validity.
no, Milord, your lordships,
I am not
your
even at
lordship's
this
judgments
stage-
all
I'm
say,
Not even at this stage asking that he show it to me. That we will see, my lord, your lordship's will. Why does he not show it to you? Neither the learned attorney nor the RBI counsel are willing to share full papers with your lordship. What
Milord,
are they
this-
holding back?
our-
What are they hiding?
Milord, this is exactly, Milord, the kind of
Nothing is being
prejudicial
held back,
submission.
Nothing is being hidden. Of course, I will show it to the court if necessary. The court asks for it.
All right, we will continue tomorrow, right? Tomorrow.
Yes.